A little bit more about this police officer facing charges of murder. I'm not going to discuss this specific case, but a few people have asked and said, well, why is it murder? Why is manslaughter not on the table? Okay, so we need to look at the use of force. Use of force is dealt with by something called Section 3 of the Criminal Justice Act 1967, which states that you can use force to prevent either harm to yourself or another person. What's the test on that? Well, it's a two-part test. The threat element is purely subjective. It's what is your honest belief as to the situation at hand. Even if that belief is mistaken, so long as it's an honest belief, that satisfies the first part of the test. That's for criminal law. It is actually different for civil law. In civil law, that belief has to be reasonable. This also might be relevant because when it comes to police disciplinaries, they actually apply the civil test, not the criminal one. But that's hurdle one. The second part of the test is, was the use of force in relation to the threat as you honestly believed it, was it reasonable, necessary and proportionate? And that's an objective test. That is, what would your average person do in that situation, facing the situation as you thought it was. But here we've got a situation where somebody used lethal force. Now, the mens rea for murder, that is, what is the mental element? It's an intention to either kill or just commit serious harm. And obviously, shooting somebody, you intend to commit serious harm. Might be the last thing in the world you want, but the legal definition of intention is your voluntary act has these inevitable consequences. So basically, yes, the officer, presumably, or an officer, let's keep this hypothetical, obviously intended to commit serious harm. And if as a result of that somebody dies, it used to be within a year and a day, now there's no time limit, although if it's more than 3 years, say somebody's been on life support, then actually the Attorney General has to approve the prosecution. But in this particular case, so somebody shoots somebody. However, the use of force has to be unlawful. That's the same for any use of force, whether it's assault, ABH, GBH or murder. And it's for the Crown to show that the force was unlawful. It's not for you to prove anything. If you say, I was acting lawfully under Section 3, the Crown have to prove to the requisite standard, i.e. so that the jury is sure that the force was unlawful. But the situation is there, it's all or nothing. It's either murder or you are totally innocent. There's no option for manslaughter there. I mean, unless you go into sort of things like diminished responsibility. Because manslaughter is where you do an unlawful act and that results in the death of somebody. But in this particular case, manslaughter doesn't fit the facts. It's like, yes, I deliberately shot that person because I thought they were a threat. So he wasn't being reckless or anything like that. So yeah, this is going to present, some difficulties for the defence. Another reason we tend not to add manslaughter is there's always this idea that if you put sort of an intermediate count on there, there is always a danger that a jury might just go, let's just split the difference and let's just convict on that. Because we're not sure if it's murder, but we're not sure if it's completely innocent. We'll just go halfway house. So that's the position. So that is why it's murder. Why the charge is murder. And we'll just have to see what happens. And like I say, that's of general applicability. I'm not speaking in relation to any one particular case, because unlike the Home Secretary, I have actually read the CPS's press notice saying not to. Anyway, if you found that useful, interesting, or whatever, please consider clicking the like button. Also, it'd be nice if you could subscribe, because about 95% of people who watch my videos aren't subscribers. So feel free to just click that little bell icon or whatever it is.